So we will give them these power to give sometimes to the Court of Quebec judges. So we estimate that if they are used with their full potentially, it will be 15 to 20 judges of the Court of Quebec that will be used for trial.
That's some of what Justice Minister Simon Jolin Barrette announced today, the idea here being to try to finally be able to clear some of the backlog of cases clogging up the province's court system and speed up the legal process. Now, there's an issue of justice of the peace. There's an issue of being able to use, video conferencing as well. Julius Grey is a Montreal constitutional lawyer. He is on the line. Mr. Grey, thanks for your time this afternoon. Seems to me we've been talking about this for an awfully long time. Every time a case comes up, the Jordan ruling begins to apply. We wonder, when is this ever going to be fixed? So is this a step, do you believe, in the right direction today?
Well, it surely is in the right direction in the sense that it provides some more manpower. Mind you, it doesn't name new judges, so it's presumably the minister considers that some of them are underused. But it may well be that it will prevent a few applications of Jordan. It only applies, of course, to criminal law. And in addition, it doesn't solve some of the more basic problems with criminal law or civil law. One thing is that the law is terribly expensive and people can't afford it. The accused, only the very poor who are eligible for legal aid, that has problems, and the very wealthy who don't care are unaffected. But justice is still not generally available, and civil justice is very difficult to get. Secondly, I think one of the ways in which we could have more space and more time, which isn't being tried, is decriminalizing more things. We shouldn't be having criminal trials with subsequent criminal records and the destruction of lives and careers for petty assaults, for fights, for minor thefts, and so on. I know that's unpopular because the public generally thinks that hardline criminal law is the way to go. But obviously, I think you'd save more time by having fewer offenses and not punishing the petty things and with the heavy hand of criminal law. It would do more. So while I think what the minister has unveiled will possibly, I don't know, he says he gave a number of judges who might be saved. I think he's being optimistic, but it might have a little bit more, give you a little bit more manpower. There are other things that are not being done. We're not lowering the cost of justice. We're not reducing the number of offenses, which surely is the way to go. Be a less punitive society and less concerned about somebody breaking minor rules, especially those that don't have a serious moral side to them. So it's a start, but I think a relatively weak start.
Well, let me ask you in reference to what you said about some of these issues not ever going to court at all, like you mentioned petty assault. How do you think those should be treated?
I think there are ways of doing it with conciliation between victims and the perpetrators. It's not when they're not major things, when they're not murders or attempted murders or whatever. I think they could also be treated by community work without a criminal record, by orders restraining contact with certain people. If you think that you've had a fight, a year or two without speaking to somebody, there are all sorts of ways of doing it without what I consider the very punitive arm of criminal law. Because criminal law, remember, if you get convicted, it pretty well wrecks your life.
Are there other jurisdictions doing this that you can look to say, look, it's been effective there, why don't we consider it here?
Well, there are other jurisdictions that have decriminalized more. I think in Scandinavia things have been decriminalized for a while. I think in Canada we've decriminalized cannabis, and it hasn't been a disaster, far from it. I think there are still some problems with overconsumption, but one could easily imagine that would be a model for reducing the scope of criminal law. I think and as I said, I think providing more help for defendants. The other thing is simplifying things, having fewer procedures, having less formality. I think jury trials, for instance, I've always been against jury trials. I think they're incredibly expensive, and they don't bring anything that could not be done otherwise.
Let me ask you, one of the things that was mentioned today by the minister was this idea of giving more authority to justices of the peace. And I don't really know, I'm not sure too many people do, what responsibilities they have now. Is that, in your mind, a good decision, a good choice to give them more responsibility?
Well, they do have, they're justices of the peace are people who do justice without necessarily being full-time judges. They're given certain specific jurisdiction and on minor offenses, traffic, things like that, signing introductory motions, and so on. It's a cheaper form of justice than naming a judge, who is, of course, for life and has to be for life and has to be very well paid, and so on. So I think it's an economic measure. Could you do it by people who are less secure? Of course, you have problems there, because one of the great things about our justice system is the independence of the judges, their complete indifference to the result, and so on. So using semi-judges has its perils, but obviously you can, and you can, and the type of things the minister wants to give them are not really things that are going to be affected by notions of partiality and so on.
Okay. I would ask one thing. I think you mentioned this off the top. The idea that what we didn't hear today from the minister was that more judges would be appointed. Is there a reason, do you think, for that? Why is the hesitation to do that?
Well, there may be economic reasons. Also, a judge is expensive. We're talking about provincial judges. If the federal government were to name more superior court judges, the minister in Quebec would not be spending much more money. But a judge is a significant investment. And I think what they're trying to do is invest a little less.
Okay.
They should say so.
One last thing before we wrap up, not to do specifically with this, but we were talking on the show last week about the notwithstanding clause being renewed for 5 years so that Bill 21 could remain in effect. And from what I understand from the people we spoke to, the appeals court here in Quebec should be issuing a judgment on this soon. I heard from, I think it was Gabriel Nadeau-Dubois of Quebec Solidaire, they're expecting possibly in weeks. Do you have any idea when that is coming?
Well, I'm involved in it. I represent some of the intervenants, and we've been waiting for a year and a half. It's an unusual amount of time to wait. On the other hand, one can say in the court's defense that it's an unusual type of case with a number of significant issues, not just one significant, important issue, but a number. So the court, but I do believe the court will issue a judgment within a month or two, and it will inevitably go to the Supreme Court of Canada. But then the notwithstanding clause is being used all over the country now. Mr. Harris wants, everybody wants to use it.
Will that come into play in a decision here, though?
No, it doesn't matter. But I mean, I think what we've watched is an attrition of basic rights in the last few years, and Premier Legault is the one who started it, or at least started it. The frequent resort to this draconian measure, I think it was intended that the notwithstanding clause be used for truly exceptional cases, and not just because the government feels strongly about something, but now all over the country, we find that governments are so blinded by their own desires and their own ideologies that they're prepared to take away from the Charter its primacy. And that's what was intended when we respected basic rights. We want them to come first.
Mr. Grey, appreciate your time as always. Thanks so much.
Thank you.